24 at Oak Street. Appreciate the mayor being here. I think that this will hopefully fall on your ears and you'll take some action with this, and hopefully Mr. Henry can educate me as possible, because it seems a little bit of what I'm going to talk about today was pretty easy for me to find, so I figure I must be wrong, but I'm going to go ahead and approach this anyway. And I think before I get started, I really commend the last gentleman. I think it's tough for good landlords like that with the law written the way it is, and I think that it, possibly if we could adapt it to be only drug dealers or gun-related activity. I don't think by putting our citizens in jail for simply drug use it's going to solve the problem. Making criminals out of them, I think that obviously we've got to rehabilitate them. With that being said, Sherman Hills obviously has been an issue for years. I did a little bit of research on how we could possibly get that addressed. The reinstatement of torts here, section 821B, defines a public nuisance as an unreasonable interference with a right common to the general public, and I think safety and living in our homes, unabated by violence, would be one of those common rights. And the courts wanted some greater precision in defining it, so they said that an unreasonable interference with a right common to the general public by a person or people with control over the instrumentality alleged to have created the nuisance and that caused the public nuisances. So 4 key elements. Whether an interference with a public right is unreasonable depends on the activity in question and the magnitude of the intrusion. Analogous to the private nuisance analysis, liability for public nuisance requires that the interference creating activity be intentional, negligent, which I think is key in this part, reckless, or for that which strict liability attaches based on participation in abnormally dangerous activity. Moreover, the interference must rise to the level of unreasonableness. Subsection 2 provides 3 non-exclusive circumstances in which an interference may warrant finding of unreasonableness. Conduct of a substantial interference with public health, public safety, public peace, public comfort, and public convenience. Conduct that is prescribed by statute, ordinance, or administrative regulation, and conduct that is of a continuing nature has produced permanent, long-lasting effect, and to the actor's knowledge has a substantial detrimental effect on the public right. The court may undertake traditional harm versus social utility analysis, balancing the nature and gravity of the harm against the utility of the conduct and the burden of cost of preventing harm. If the harm caused by the defendant's conduct outweighs the social utility of the conduct, the interference with the public right will be deemed unreasonable. Regarding to public nuisances, Pennsylvania courts have adopted Section 821B of the Reinstatement of Torts for elements of a claim for public nuisance. And an action that may be declared a public nuisance as a matter of common law if, though not prohibited by statute, it unreasonably interferes with the rights of the public. So it doesn't necessarily have to be illegal what they're doing. The Pennsylvania Supreme Court has held an activity that may also be a public nuisance because it has either been so declared explicitly or implicitly by statute. For example, Title 68, Section 467 of the Pennsylvania statutes explicitly states that any building used for the purpose of prostitution is declared to be a common nuisance. Likewise, in Pennsylvania SPCA versus Bravo Enterprises, the court held that bullfighting was public nuisance prescribed by statute, even though the statute did not explicitly declare it to be a public nuisance. A lawful business may be required to cease operating in a particular way, and it is shown that under particular circumstances, its operation constitutes a public nuisance. In Reed versus Brodsky, a taproom restaurant was located in an exclusively residential neighborhood. Its patrons, who came largely from other neighborhoods, threatened to destroy the character of the residential community by their actions. And that bar was, in fact, shut down. The Pennsylvania legislature has enacted Title 18, Section 6504 of the Pennsylvania statute to criminalize public nuisances. Whoever erects, sets up, establishes, maintains, keeps, continues, or causes to be erected, set up, established, maintained, kept, or continued any public or common nuisance is guilty of misdemeanor in the 2nd degree. Where the nuisance is in the existence at the time of conviction and sentence, the court may, in its discretion, may direct either the defendant or the sheriff of the county at the expense of the defendant to abate the same. So basically what it's saying is, even though they're not technically breaking laws, if they're being a detriment to our community, we can file a lawsuit against them. And I would ask that the mayor request that of the city attorney to go ahead and file that, to require them to go ahead and provide security guards. There's 344 residences in Sherman Hills, probably about 700 people living there. If you had 700 people in any other building, we would require security guards at it. And I think that it's only in the public's best interest and I'd be curious if I'm mistaken about what I'm reading here.
Well, I mean, that was quite a lot. You spent almost a chapter.
It was, I understand.
I'd like the opportunity to maybe look at it, digest it. I didn't know I was
Certainly,
the bar.
I actually brought materials here, and there's some web links. The one document I referenced was from the American Bar Association, and the other one was from a law student at Penn State. So I think both should be relevant. Again, I'm not a lawyer, so I do not know the exact legalities, but to me it seems like we have good standing to go ahead and file a lawsuit.
If you want to give a copy of the packet you have to the administration, and the administration desires I take a look at it, I certainly will.
That's something that we looked at and used that.
No, that's all for you. Go ahead. I have many copies at home. That's fine.
You're lucky you didn't stutter.
It was close. It was close. But thank you for your time.
Okay.